Good afternoon. I hope everyone online can hear me loud and clear. My name is Alex Kuczynski. I'm the Director of Legal and Information Management at the Bar Standards Board. And I'm joined today by Rhys. Rhys, would you like to introduce yourself?
Yeah, hi everybody. Thanks for joining. I'm Rhys Bevan and I'm Head of Legal.
So thank you for joining us this afternoon. We're here to give you an overview of the consultation paper which we published a fortnight ago on some in-principle proposals to change or review our enforcement powers and procedures. In the time allotted of an hour, it will be a little bit of a whistle-stop tour, but we're very keen to alert everyone as to the publication of the consultation paper, which is wide-ranging, has a number of proposals, I think about 34 in total, which affect to a large degree the operation of our powers and procedures. They are in principle at this point. We do not have draft regulations. As you may have picked up, this is part one of the process. It will be followed by a second consultation next spring, when in the light of responses to this consultation, we will be proposing draft enforcement regulations to take effect from January 2027. Although that feels a little way away, there is a lot for us to do between now and then. And I thought just before we get into some of the detail of the consultation proposals, which we'll be taking you through this afternoon, it will be helpful to provide a little bit of context. So the context is in the light of a wider reform programme that the Bar Standards Board is undertaking. There have already been some activities to improve our enforcement process and procedure which are not dependent on the regulations, as part of what we call our Modernising Delivery project, building on recommendations which you may or may not have seen published following a report, an enforcement review by Phil Fisher. We published that in April 2024. We're keen to progress this consultation to give full effect to the aims of improved fairness, transparency, efficiency and effectiveness of our enforcement system. We think that provides wide benefits to barristers, to third parties, witnesses and others involved in enforcement proceedings going forward. We're very keen to hear from all stakeholders, the profession, but wider too, on these proposals. Thematically, they comprise an element of case management, enhancement and efficiency. There are some simplifications and clarifications to current practices and regulations, codification of understanding, and substantive proposals around panel composition, fitness to practice, and interim suspension regimes. We have carried out some initial assessments of equality impact and data protection, which we'll be coming back to in the light of responses and evidence collected during this consultation. We've also drawn on past experience of operating the current regime over recent years and collected some initial stakeholder feedback through a stakeholder group which represented users of the enforcement regime, but also those experienced in similar disciplinary regimes in other sectors, other regulators and solicitors. So with that introduction, I hope that's clear. We're going to take you into the consultation proposals themselves. Rhys and myself will divide these by the different parts of part 5 of the handbook, and we'll conclude with discussing the proposals around panel composition and open justice. So on that note, I'll pass over to Rhys.
Thank you, Alex. So I'm going to start with taking you through the proposals that we're making to the enforcement decision regulations, which is part 5A of the handbook. To put that in context, the enforcement decision regulations govern our initial assessment and investigation work. The proposals that we are seeking to consult and get feedback on, there are 5 of them, and they're primarily designed to introduce efficiencies to our investigation process, whilst some seek to clarify or codify existing practice. So, firstly, we're proposing to defer the communication of written allegations of potential breaches of the handbook until the investigation by our investigation team is more developed, at a point when the BSB has gathered more evidence and has a clearer idea of whether there is evidence of a potential breach of the BSB handbook for the barrister to comment on. This proposal, it's the proposal to defer the timing at which we notify barristers of the written allegation, should lead to clearer and more accurate allegations. It's important to flag that the Field Fisher review of our enforcement system, which was published last year, raised concerns about the BSB's current approach of sending detailed written allegations at the outset of an investigation, because this can mean that there's insufficient evidence at the outset to draft particularized allegations, and that can create subsequent issues, including delays. While we intend to amend the enforcement regulations to clarify the approach that we are setting out in the consultation paper, we are also proposing to implement this change of practice sooner under the current regulations. And this is because the current regulations are not specific as to when the written allegation should be shared with the barrister for comment, provided that the allegations are shared before the conclusion of an investigation. The other proposals in relation to Part 5A are a proposal to introduce a narrow power for decision makers to amend or add the written allegations, where doing so does not lead to unfairness to the barrister. So the intention there is for decision makers to be able to amend or add allegations without having to put the allegation back to the barrister for comment. And obviously it's important to stress that that would be limited to circumstances where the amendment does not lead to unfairness to the barrister. Feedback from members of our independent decision-making body, from whom panels of decision makers are drawn to make decisions on whether to refer cases to disciplinary action, fed back, and this is referenced in the Field Fisher report, that it would be of considerable benefit for there to be such a power. And while we hope that our proposal, which I just talked through, to defer the point at which allegations are notified to barristers for comment, while we hope that that proposal will reduce the need to amend allegations, we are nevertheless seeking feedback on this, because there may be cases where it will be helpful to the BSB in order to expedite cases, again, where there's no unfairness to the barrister in doing so. Similarly, we're also seeking feedback on a proposed power to add allegations of non-cooperation with the investigation without the need to go back to the barrister for comment. But it's important to stress that that is provided that the barrister has already been notified of the risk, or this risk of non-cooperation. The third proposal in relation to Part 5A is a proposal to speed up the decision-making process by giving staff the power, but not a duty, to refer all criminal conviction cases directly to disciplinary action where they're satisfied that there is a realistic prospect of a finding of professional misconduct being made and it is in the public interest to pursue disciplinary action. The fourth proposal is amending the powers around reconsideration of post-investigation decisions. So this is the stage of our investigations where a decision has been taken on an allegation, and there may be a request to reconsider that allegation. And to address inefficiencies in dealing with those requests for reconsideration, in cases where the decision is taken by panels of our independent decision-making body, we are proposing that those requests are first considered by the chair or vice chair or somebody appointed in their absence to review the request for a reconsideration and decide whether the criteria for the reconsideration, which is set out in the enforcement decision regulations, whether the criteria are met. If they're not met, that will be the end of the matter. But if they are met, then the matter will be referred to a panel of the independent decision-making body to decide the outcome of the reconsideration. And finally, our fifth proposal in relation to Part 5A concerns confidentiality of reports and investigations. So while there's no change to the principle that confidentiality is relevant to the assessment and investigation of reports and allegations of breaches of the handbook, we want to clarify the regulations to make clear that the BSB can disclose information, and whether that's internally or externally, in order to further an assessment or investigation. So this proposal is not a substantive change in principle, but it's really a clarification of our ability to disclose information where necessary for the furtherance of an investigation. That's the full extent of the proposals that we're seeking feedback on in our consultation for Part 5A of the handbook. And Alex will now talk you through the proposals in relation to Part 5B.
Yeah, thank you, Rhys. So Part 5B are the disciplinary tribunal regulations, and they reflect, as I said in my introduction, two relevant themes in these proposals. The first is the case management and increased proactivity provided to BTAS as the tribunal's service to manage proceedings, and the second is to clarify and codify existing practice and understanding. So in terms of case management, we propose introducing an overriding objective for the tribunal so it can act justly and proportionately, and to give it a limited power to regulate its own procedure within the guidelines, and recognising that overriding objective, and greater case management powers, including case management questionnaires, but importantly to be able to set timetables and require compliance with timetables by the parties. We're very keen that these proposals, if implemented, result in quicker outcomes for all involved. And we think by providing BTAS as the tribunal's service with this increased authority, that would help considerably. There are a few proposals then which clarify what our current practice in many cases. One is when sanctions come into effect, to have a consistent approach and understanding that in the event sanctions are ordered by a tribunal, they come into effect on the conclusion or the expiry of a period for appeal or the conclusion of any appeal, rather than have to deal with that case by case. To clarify that both parties, including the BSB in particular, can make representations on the question of sanction. To clarify that the BSB has a right of appeal, just jumping on, sorry, to the next page, clarify the right of appeal where cases are partially dismissed. A couple of others on this page which may be a little more a change of practice. So one is service by email. At the moment that is dependent on consent, and actually we think that should be the default method of service, assuming we have a reliable, current, up-to-date email, which in most cases that is so. There may be a few where that's not right and not possible, and we'll have to think of alternative service, but we think email now is clearly more convenient way of doing business. I should say on costs, we want to clarify the entitlement to costs from the moment that matters are referred to the disciplinary tribunal process, that the BSB cost of of preparing for that hearing can be recovered, but we are not, importantly, not here seeking to recover internal costs. This is externally incurred costs such as the BSB counsel or experts, but also transcript providers and the like. But as I say, just to repeat, this wouldn't be internal BSB case management, case staff costs. And then finally, here at the bottom of this page, but importantly, we've become increasingly aware of the importance of anonymity for witnesses, particularly as we say in cases where there's allegations of sexual or violent nature. At the moment, anonymity is provided to witnesses, but it's not a presumption. It must be applied for. We think that is a bit of a hindrance. It's a rebuttable presumption, but the presumption which we think will reassure witnesses in engaging with us and with the process would be of anonymity in the proceedings. It's not to say they would be unknown to the individual barrister, but publicly their identity would remain undisclosed. And we come on later on to talk about the hearings and open tribunals, and obviously arrangements that need to be made in these kind of situations to protect the anonymity of any witnesses. So that's the suite of reforms we have proposed in principle for Part 5B. So we're moving now to two different regimes, interim suspensions and fitness to practice. And Rhys is going to do the first of those.
Thank you. So Part 5C are interim suspension and disqualification regulations. They deal with the BSB's ability to take urgent action pending disciplinary proceedings. The primary purpose of this regime is to take action in the public interest and to protect the public and the interests of clients. And so two of the proposals that we're seeking feedback on in the consultation concern the grounds on which we can refer barristers to an interim panel for a decision on whether to impose an interim suspension or other order, and the grounds on which the panel can ultimately decide whether to impose an interim suspension or other interim order. So we're proposing to simplify and reduce the grounds to refer a barrister to an interim panel. And that will be a reduction of the current grounds, which are 5 and to 2, with the emphasis being on whether a referral is necessary to protect the public, or is in the public interest, or is necessary to protect the interests of clients. Interim panels, when deciding whether to impose an interim suspension or other order, will be making the decision using the same grounds. So we'll be aligning both the referral stage and the decision-making stage so that the same grounds apply to both stages for a consistent approach. And again, to reflect the public interest, public protection and client interest importance of this regime. And we will be also proposing to amend the grounds on which the chair of the independent decision-making body can impose an immediate interim suspension. So this is a power that the chair of the independent decision-making body has currently got. Where a referral is made by the BSB to an interim panel, the chair must consider whether or not the case is such that it warrants an immediate interim suspension, pending consideration by an interim panel. The proposal is to amend the chair's power to broaden it so that it can be imposed where justified, having considered the risk to the public or the public interest if one were not imposed. This is an addition to the current power, which is currently limited to a risk to the public. So we're suggesting to broaden that to include reference to the public interest. The next proposal that we're consulting on is about the listing process, and we are proposing to streamline the listing process. So this is the process by which we list hearings of interim panels. Currently, there's quite a convoluted process that involves the provision of various dates, opportunities for challenges to those dates and the offer of alternative dates, and then decisions by BTAS as to which date is preferable to list a hearing. And that process can generate significant correspondence at the outset solely for the purpose of fixing a hearing. So we're proposing to streamline the listing process, and our proposal is to give barristers reasonable notice of a hearing which must be listed within a specified number of days following the referral. And that reflects the need for these cases to be considered quickly, given their urgency to protect the public on the public interest. We're also consulting on the proposal to remove a power that currently exists in the regulations. And this is a power of interim panels to refer cases directly to disciplinary action where a referral at the time the interim panel considers the case hasn't been made by the BSB. As far as we know, this power hasn't been used before and risks, in our view, unfairness by circumventing our usual process of investigation, by not giving the barrister an opportunity to comment on the allegations of potential breaches of the handbook through our usual investigation process. And so the proposal is, as I said at the outset, is to remove the power for panels to refer cases directly to disciplinary action and to use our current disciplinary process and investigation process to ensure that this happens. We're also proposing to extend, I think it's the next slide, thank you. We're also proposing to extend the right to request a review. So there is currently a right of review by a barrister of interim orders, and we're seeking to expand that by conferring the right to request a review on the Bar Standards Board as well. And aligned to that, we propose to make some clarification changes to the process that requires both parties to have an opportunity to comment, make representations on the other party's review request, and to be notified of the outcome of BTAS's decision. So that's the tribunal that administers these interim panels, their decision as to whether or not to convene a review panel. So that those changes are more by way of clarification of what should be fairly standard practice. And then the final proposal in relation to Part 5C is about giving disciplinary tribunal panels the power to determine review requests in relation to interim orders where the disciplinary hearing of related charges of professional misconduct has already commenced. Currently, the regulations provide that in such circumstances where there is a review request made, but the disciplinary hearing of related charges has already commenced, jurisdiction to consider that review request falls away. With hearings being adjourned, this can lead to barristers with no recourse once the hearing has commenced until a decision on the charges has been made by the disciplinary tribunal. So we're proposing that the disciplinary panel has powers to consider review requests. And this is to avoid parallel processes happening at the same time, and because disciplinary tribunal panels should by then be apprised of the facts and well placed to review an interim order. That's some of our proposals in relation to the interim suspension and disqualification regulations, and Alex will now talk you through Part 5D of the handbook.
Thank you. So that's currently labelled the fitness to practice regulations. And as we say in the consultation paper, they have been rarely invoked in recent years. So we've had a bit of a root and branch review of this particular regime to think, is it correctly structured? And is the intention and purpose of this regime clear? The label itself may be confusing or act as a deterrent. So to avoid that, first kind of thing to note, we want to rebrand fitness to practice as a health regime. So to be clear that it's to deal with cases which we define in the proposal as a health condition, and a health condition is termed a physical or mental health condition, including addiction. So to get away from any connotation of disciplinary issues or sort of professional competence issues. And we'd read that through to the structure and terminology, so away from references to preliminary hearing or full hearing to term those meetings. We hope that would make the general structure of the regime more sympathetic and more usable where it's appropriate. The second decision, or the second proposal on which we are looking for feedback, is the test. So at the moment, that's a relatively high test, incapacitation, which we also think makes the regime too rigid, and we would like to use impairment as a test. Now, we're concerned that doesn't become too low a threshold, so it has to be linked to the risk or the threat to public interest. So the imposition of any restriction or condition in the circumstances where there is impairment on the ground of a health condition must be necessary for the protection of the public or otherwise in the public interest. And we think that strikes the right balance, but of course we'd be keen to hear views. In terms of the actual operation of the fitness to practice, or what hopefully will become the health regime, we want to clarify the convening of the panel and fixing of the hearing date to make that more usable, more user-friendly, and we'll talk about the composition of the panel a bit later on. We want to be able to be more flexible at the Bar Standards Board to be able to accept undertakings prior to a referral, again, to avoid having to go through a process which might prove unnecessary if we can clearly agree a set of undertakings to deal with the health condition to the satisfaction of us as the regulator, but equally the individual barrister. And we want to resolve what we think is a curious issue of the length of order. So at the moment, the orders are limited to 6 months. I think we're not quite sure exactly why that is the case. We don't feel having a fixed term or a maximum term of that duration is right. So we have two options on the table. One is unlimited orders, and one is up to a maximum of 36 months. It's one of those where we haven't got a single in principle proposal. It's one we've got two offers on the table, which we want to hear about. Both have advantages. In both cases, obviously, we'd be keen to keep that under review to make sure that we were responding to any improvement in health condition, that we were able to monitor health conditions that were receiving treatment, and if necessary, to review and extend orders. But we think that provides a more comprehensive and coherent approach to dealing with barristers who might be suffering from what we've defined as health conditions. I think that takes us on to panel composition. So I think I mentioned just we want to clarify some of the flexibility to give interim conditions at preliminary hearings, and also to be able to review, particularly if you have unlimited orders, but in any event, for barristers to be able to bring matters back to the tribunal. So I think that probably takes us on to what we know is quite a substantial issue, which will be of keen interest to many, panel composition.
Thanks, Alex. So I'm going to talk about these proposals together because they're all sort of interlinked. And I would stress the point that we are consulting on a range of options and seek feedback on the options put forward in relation to these proposals, where we haven't really reached an in principle view on the direction of travel. So these all relate to the composition of panels in our sort of enforcement, mainly our disciplinary, but also our health processes. So firstly, we're seeking feedback on proposals to change the current composition of our disciplinary tribunal panels which currently consist of either 3 or 5-person panels, depending on the seriousness of the charges, the underlying potential misconduct, and therefore the sanctioning powers vary according to the level of panel that's constituted to consider the charges of professional misconduct. And our proposal that we're seeking feedback on is to change the panel composition so that all panels will in the future consist of 3 members. Alternatively, we're seeking feedback on whether actually we should retain 5-person panels for the more serious cases. The move to 3-person panels would address practical difficulties and delays that can be caused by scheduling around the availability of 5-person panels, particularly the availability of the judge and barrister members of the panels. And this was an issue that was raised in particular, again, in the Field Fisher report of the enforcement review, which was published last year. The proposal to change to 3-person panels also addresses inherent inefficiencies where a 3-person panel considers that it's got inadequate sanctioning powers and refers up to a 5-person panel, which inevitably causes additional delay in the disciplinary process because of the need to refer and reconstitute and list a hearing with a 5-person panel. Moving to a 3-person panel would also bring us into line with the approaches of many other professional regulators. Now, the 3-person panel under the proposal set out in the consultation would include a requirement for a legally qualified chair. But the proposal in the consultation is that we remove the need for that chair to be a KC or a judge, which is the current requirement depending on the level of panel. We would require the legally qualified chair to have at least 15 years practicing experience to ensure that the chair has got sufficient experience and capability. But I would stress that the 15 years practicing experience, which is picked up and mentioned in the consultation paper, would not be the only eligibility requirement. There would be additional eligibility requirements that would be developed for the recruitment and selection process to ensure that candidates hold sufficient other experience and skill sets in order to fulfill the role of panel chair. The legally qualified chair would therefore be able to be a barrister, including KCs, solicitors or silex lawyers, and judges would of course still remain eligible. It just wouldn't be a requirement. Panels would therefore comprise of a legally qualified chair, a member of the profession, and a lay member. So there would be a legal majority, but not necessarily a barrister majority. And we propose to make similar changes for similar reasons of scheduling and availability in relation to our IDB panels, which are currently 5-person panels considering enforcement cases, and our health panels, which currently under the fitness to practice regime are also 5-person panels. For the IDBs, we would retain a lay majority as currently. And in relation to the health panels, we're also seeking feedback on a number of options in relation to how those panels may be constituted. One option is that we have a 3-person panel who will be supported by a medical advisor to give medical advice to the panel, or alternatively, a 3-person panel which will include a medical member as a member of the panel and therefore as a decision maker, which reflects the current approach to panels under the existing regulations. And then the 5th proposal in this sort of area in terms of panel composition and the conduct of disciplinary proceedings concerns the panel secretary role. Currently under our disciplinary regime, the disciplinary tribunal panel is supported by a clerk, a role that was historically fulfilled by a junior barrister, but in practice has increasingly been fulfilled by a member of the BTAS staff due to resourcing issues. And the proposal that we're seeking feedback on in the consultation is to replace the clerk with a new panel secretary role. The panel secretary will formally be a member of staff at BTAS, that's the Bar Tribunals and Adjudication Service, who administer our tribunals and disciplinary panels. And that secretary would cover the duties undertaken by the clerk under the current regime, but may also include some additional support for the panel. For example, potentially assisting panels in drafting decisions. So there are proposals in relation to panel composition, and we obviously seek feedback on those in particular. And Alex will now talk you through other issues related to transparency and accountability.
Thanks, Reece. So we're on to the last three proposals. And the first is also relevant, I think, to the case management proposals that that touched on earlier on, because that's where it would take effect. But we've put it into this part of the paper because it will affect the publicity and public access to hearings. So just by way of context, this is about the publication of disciplinary cases. So when the public become aware that there is a case proceeding brought by the BSB. Now, at the moment, that point of awareness is pretty close to the actual hearing before the tribunal. So the convening order stage, which is about a fortnight before. And to appreciate that can be some time after the charges have been brought and served, many months, even a year or two. So our proposal to make the process more open, more transparent, and also to alert possible witnesses and other interested parties to a case, is to bring forward the publication of the charges. Now, this is another one of our either-or options, and we've got two on the table. The first is publication by us at the BSB upon the service of the charges on the barrister. So we have gone through the process of serving the allegation and had engagement with the barrister, but we would have made the decision at this point to proceed. The second would be publication by BTAS at the point or shortly after the first case management directions conference. We're keen that there is a fixed point rather than a point that is left to determine case by case. We think that is helpful to everyone to know when this would happen. But we've invited feedback on those options. What we recognise is there may well be issues that a barrister or other individuals might want to bring forward in terms of anonymity at this stage. So any process would need to factor in how that is determined, either by us at BSB or by BTAS, were it to be at that first sort of case management direction stage. And you can see there might be advantages in either of those. That decision then also has an impact on the subsequent issue on public and private hearings, because from the point a matter is public, we then go on to propose that interlocutory hearings, not just a full tribunal stage, the interlocutory hearings would, any absent reason to have those in private, would be in public. So that would only be actual hearings, not sort of agreed directions and the like, but where there was an active live hearing, that would be listed, it would be publicised, and members of the press, media, whatever, public would be able to witness those in person. This is the one part of the consultation paper where actually we've gone out of the enforcement regulations remit, which we thought would be helpful, because we have included a table where we set out the different alternative sanctions that we can take, not just those which go to tribunal, but included the administrative sanction and determination by consent procedures, on which we're not raising for further consultation, but we think are helpful to set out in terms of access, non-party access and publicity. Because at the moment, the administrative sanction and the determination by consent proceedings are private. Now, although in the latter it's published, the determination by consent is published because of the nature of its findings, the hearings are and would remain private, but there would be a change in terms of but so there'd be no change there, but there would be a change in terms of the case management of a full tribunal. We're not proposing a change around the publicity of interim suspension hearings. They would be private because of their interim early nature, but the outcome would be, we think, in the public interest to be public, and you'd appreciate that any sanction, condition, restriction on a barrister at that point is likely to be relevant to the public, clients and the like. So the substantive hearing, though, would, as I say, be public. The final one, of course, is fits to practice, or as may be the case, the health regime. Again, you'd appreciate, because of the sensitive nature that is likely to be the subject matter of those kind of cases, they would be private, absent a request from the barrister to have a public hearing. The outcome isn't currently published, but we are considering whether that might be the case. But largely, that's going to be, say, a matter that is going to be private. So you can see that's a slightly broader scope for the consultation, because we're not just looking at the enforcement regime, we're looking at some of the other tools that we have. So I think that proposal 34 is the last proposal. As I said, the next steps are the consultation period. We know it's a chunky document. It's a consultation period which is going to run to the 15th of October, longer than usual, recognising not just the scope and breadth of issues, but also it's over the summer, and we want to give everyone ample opportunity to think about the issues that we've raised and be able to formulate and submit responses. We hope that what we've done is give you a sense of the purpose and the scope of this consultation, and be able to enable you to sort of focus on those issues that you want to engage on. And just to repeat, following the responses, we'll be considering obviously that in due detail, appropriate time, but we have the target of a consultation on any revision to the regulations in the spring. That's over next spring, early summer, and to make those regulations early autumn to take effect from January 2027. The one exception being that we are proposing a change in the process to the allegation proposal 1, although we will reflect that in regulations at the conclusion of this consultation. So depending on feedback, that could be earlier, say the beginning of next calendar year. So I think that takes us to the opportunity to invite any questions and answers. You'd appreciate that we're here to talk about the consultation paper, the proposals, so we're not in a position to talk about individual facts or cases. That's not what today's about. It's really to raise your awareness about the consultation and to try and engage on this process. So on that note, I'm happy to see if we have any questions in the last 10 minutes or so.
I'll just add that questions can be submitted in the Q&A function on the Teams chat.
A lot to take in. I appreciate. I hope that the length of the consultation period will afford you the opportunity to think about these, and obviously consult with colleagues, I'm sure, who will be equally interested in what we are talking about today.
Yeah, and I think the email address may have been on the previous slide if you want to bring that back up, but if there are further questions on the consultation after this event, then please do contact us at that email address, enforcementregs@barstandardsboard.org.uk.
Right, I think any particular Q&As, you got the email if you want to reach out to us, and we look forward to hearing from you with your responses. Thank you.